everyone, I'm Aaron Brooks from the ISBA Committee on Legal Technology, and I'm going to moderate a series of short discussions about eFileIL and the new expanded remote access policy that became effective on March 1st. So we're going to break this up into 3 YouTube videos that cover what's available under the new policy, specifically how you get documents under the reSearchIL platform, and we're going to finish up with an update on the status of the upcoming roadmap for eFileIL, which is sort of the under the hood engine for the whole platform. With me is Trent Bush, also from the Committee on Legal Technology, as well as Ryan Matkin, Phillip Vaden, and Chayce Adams from Tyler Technologies, who's the platform provider. Hello, everyone. How you doing?
Doing
Great.
well.
Good to be here.
So let's talk about this new remote access policy. Can somebody just kind of jump in and tell us what that's about?
Yeah, Aaron, thank you. I just want to give a little bit of background. I think it's important for folks to understand really how we got to where we're at currently. And to put things into context, as far as where we're at now, it's helpful to have that background. So I'll just give a little bit of background. In 2011, there was appointed by the Supreme Court what was then called a Special Supreme Court Committee on E-Business. And that committee was tasked with trying to move the Illinois court system forward in its e-business efforts. And as a result of that committee's efforts, which was led by Attorney Bruce Pfaff, recommendation was made to the Supreme Court in November of 2011 with respect to 3 separate items. Number 1 is that the court move towards either permissive or mandatory e-filing, that the court move forward with either permissive or mandatory e-service, and finally, that the electronic record be construed as the official record of the court. So that was in 2011. And if practitioners that were working in state courts back then realized that at that time, the federal court system had been well underway with the PACER system, with their CMECF system and electronic filing and service. And at the time, the state had implemented a pilot project concept. So I think there were 4 or 5 different counties who had gone down the path of really implementing their own e-filing solutions. So this was really the first attempt to get the state as a whole moving in the same direction. So the Supreme Court made the important step of getting this committee set up and finally getting the recommendations from that committee. As a result of that committee's efforts that was established and appointed in 2011, then comes in 2014, the Supreme Court then reconstituted a new group that was called the Supreme Court E-Business Policy Advisory Board, and that was chaired by Madison County Judge Dave Hilla. And that group, which I was on at the time and I'm still on, was then to pick up where the previous group left off in actually trying to implement the recommendations of the e-business group and the direction of the court and the desire of the court to move in that direction. So we were tasked with that back in 2014. Marching forward then from there, in January of 2016, the Supreme Court adopted its order that essentially set the time frame for moving forward with mandatory e-filing. So in January 2016, the court says, okay, everybody's going to be on the same page. Come January 1st, 2018, everybody's going to be e-filing. And so through a series of long discussions and involvement by the Administrative Office of Illinois Courts and Tyler Technologies, which we'll hear from shortly here, we have our e-filing portal of eFileIL. So that was mandatory for civil filings as of January 1st of 2018. So then, after January 1st of 2018, we now start to develop an electronic record across the state. From there, the logical next step is how to get access to those records. So in comes the remote access policy. Of course, the state system is much different than the federal system, right? The federal cases tend to be not as nearly as personal in nature, just by the nature of the federal court jurisdiction and the federal court system. So careful consideration and many discussions over the competing policies were considered, and the court adopted this remote access policy. And the without getting into the weeds of the policy, which is available on the Supreme Court website, there's kind of two important different categories throughout the remote access policy. One is it identifies the different user groups that are going to have access to documents remotely. So whether you're a judge, whether you're a clerk, whether you're an attorney, whether you're a party, whether you're not related to the case at all, you're the general public. So where you fall as a user puts you in certain categories. On the other side of that is the types of cases themselves. So whether it's an L case, an LM case, an eminent domain case, whatever, juvenile case, divorce case, that too has an important differentiation under the remote access policy. So that's really how we got to 2011, where we're just getting started with trying to herd the cats and get a unified electronic filing system in place, to now March 1st of 2021, attorneys now have access to, as the attorney user group, licensed attorneys in Illinois have access to 6 different case categories under the remote access policy.
Yeah, sounds interesting. So Ryan, I want to turn to you for a second and just kind of ask you, from the perspective of a lawyer who's new to this, this is kind of new to us all as of March 1st. What should I be doing here? How do I set up access? What are my next steps?
So actually, with us today, we do have Chayce Adams and Phillip Vaden, who are also experts in this product. But to leverage the access, it actually piggybacks off of existing eFileIL registration. So there's actually limited setup and registration that's actually required. Since we use those user accounts and IDs in reSearchIL, you simply log on with your credentials from eFileIL, and then your appropriate access will drive which documents you have access to. So Chayce or Phillip, not sure if you have much to expand on there at this point.
With that process, I think I was on mute there for a second. You also will go in and claim your bar number or your ARDC number. And I call it a bar number, sorry, Texas have it. You call it it's an ARDC number, you go in and you claim that, and then that syncs up your cases. That kind of completes the circle so that you have the cases that you've e-filed into synced up on your My Cases card in reSearchIL. And Chayce is going to walk us through that on one of the later videos, so make sure you watch all 3.
Sounds good. And Chayce, do you have a kind of a quick summary of what I'm going to be able to see there? What kinds of documents are available, and does it matter whether the document was e-filed or conventionally filed? Just kind of an overview of that.
So to kind of wrap that up and put it in a bow, pretty much anything that's been e-filed should be available on reSearchIL in most locations. However, the earlier mentioned restrictions will kind of depict whether or not you do have access to that information. But generally speaking, you'll be able to access all of the documents that you are the attorney of record on or a party of record on. And then with any documents that do have public access available, you would be able to pay for those items if you are not directly involved in the case.
And Aaron, sorry, if I could just jump in real quick, Aaron, on that point that Chayce just made. So it's important to keep in mind whether we're involved with the case or whether we're not involved with the case, right? This is remote access to electronic records. And so attorneys and parties currently have access to their own cases already, and they had it prior to March 1st of 2021. The important jump that we made with the access given by the Supreme Court on March 1st of 2021 for attorneys is access to other cases that you aren't the attorney of record or that you're not a party to. And the 6 case types, it's important, again, with the categories of who you are as a user and the types of cases, it's important to understand the types of cases that you'll be able to see that you are not the attorney of record on. And currently, under the remote access policy, with the current rules as of March 1st of 2021, you're able to see 6 case types: arbitration, eminent domain, law or L cases, LM cases, municipal corporations, and tax cases. So those are the 6 case types that attorneys will be able to see that aren't theirs, or parties will be able to see. Well, we're not talking about parties, we're talking about the user group of attorneys. So if you're looking for somebody's, let's say a family law client calls in and says, hey, I'm involved with this case. Here's what the issues are. Can you help me out with it? And you're thinking, well, I can just go to reSearch Illinois, pull up the documents and get a sense of what's going on with the case. You won't be able to do that because you're not the attorney of record. You haven't filed your appearance, and that's not one of the 6 case types. So I think a lot of the comments that we're seeing in the initial rollout of this is kind of a misunderstanding of what's actually available through the remote access policy. So it's important as you move into trying to access these records to understand what's available, so you don't think, well, the system doesn't work. Well, it's working, but as Chayce said, everything's there. The question is whether you pass through all the filters to get access to it.
Those are all great points, Trent. And one other additional wrinkle too is that for your ability to search across a jurisdiction, that jurisdiction also has to be integrated with research. And what the integration means is that that county's case management system is speaking to reSearch Illinois. So it's sending updates for document and case security. And right now, the biggest hole we have right now is Cook County. There are some others like McLean County that are in what we call repository model. And those you cannot search across currently. And this is as of April 8th, right? But Cook is going live with a new case management system this year. And when that occurs, that integration will be completed. And then that will open up to be able to search wider shortly after that go live.
And Aaron, before we jump into kind of the nuts and bolts that I'm sure everybody cares about more than the history of how we got to where we're at, but having been kind of part of these discussions for the last 7-8 years, some people may ask, well, why can't I see that family law case? Or why can't I see the LM or the forcible entry case or whatever? What we're trying to do and what the court's trying to do is balance the very private nature of state court litigation versus the public's right to access. And so right now where we've come on that kind of that scale is the court and the advisory board had kind of weighed those factors and determined, well, these are the 6 case types that have the least likelihood of revealing that information that we don't want generally made to the public, right? So those are the balancing factors that we took into account. Now, what we also have to be aware of as attorneys and as filers is that we have Supreme Court rules, specifically 138, that dictate what we can and can't file with the court as far as personal information. So part of this is also a learning process because as filers, we have a responsibility to not file information that should not be public, with the understanding that this is going to expand moving forward. So we as filing attorneys have a responsibility to know what those rules are so we can create better records to allow more expanded access moving forward.
So it sounds like we're kind of still in this transition phase, and that over the next year or year and a half, there'll be more court integration and expansion of the types of cases that are accessible to people. And so that sounds like a wise approach to kind of take it slow, get some experience and then keep the train moving forward. So, well,
Aaron, I would like to say on that note, July 1st of 2022 is the target for complete expansion for the remaining case types that the group is marching towards, to provide some context of where we're headed.
Sure, thank you.
And one other thing on the point of the privacy concerns versus right to access of these what would otherwise be public documents, right? If you went down to the courthouse. So the committee carefully also considered in those privacy considerations, what could we do to try to ensure that we don't have like these data miners and operators out there. And we'll talk a little bit about some security concerns as we start to see the product itself. So of course, Tyler has some internal behind the scenes stuff that none of us would understand and know what's going on. But We also mentioned in passing this, the per page cost to these documents, right? So similar to the federal system of 10 cents a page, $3 max per document, that too was intended to essentially introduce this concept of practical obscurity, right? So somebody's generally not going to just try to access through a computer system or just by dumb curiosity clicking on links massive amounts of data if it's costing them, right? So that is one of the reasons why also we have that cost, and that cost then flows through to the clerks to support their in turn investing into the electronic filing system. So
sure, and that seems important, right? Once the data gets scraped and indexed, the cat's out of the bag. So it's good to hear that that piece of it was thought through very carefully, right? So there's so much to go through, and so many details. We could probably talk about it all day, but we're trying to keep these videos short, and we're going to post a couple of more. I will say that if you're watching this and you have questions, go ahead and put your questions down in the comments below, because we will try to monitor those and either respond to you directly or just respond right in the video. And also, if I'm not mistaken, I think Tyler has some kind of deeper dive videos, and maybe we can post some links to those down in the video description below. So appreciate you watching, and we'll be back with part 2 right after this. Thanks, everyone.